let's start this. We need to start the second panel now. If everyone could take their seats, please, that would be extremely helpful. And I know that everyone's time is scarce, but we're going to take the right amount of time for the panel, so we're going to lock everybody in the room if we're not finished on time. So it's probably in your interest to sit down, too. They just ignore it. Excellent. Okay. Okay, thank you. So the first panel was a panel of academics discussing their research on this topic, and now we're going to turn to the industry view, and we'll see how much it's similar and different to what we've heard. It'll be interesting to compare them. We're going to go in just alphabetical order, which also by chance happens to be a good sort of mixing of the different views. And I'll introduce each speaker very quickly before they talk. Our first speaker is Ron Katz-Nelson, who is a technology entrepreneur and a named inventor on 23 U.S. patents and an independent scholar of the patent system. He's founder and president of Bi-Level Technologies, an image and signal processing technology company. From 1990 to 2005, he was at Broadband Innovations, a digital RF technology company that he founded. He's advised high-tech startups and was a professor of electrical engineering at UC San Diego, where he also earned his PhD.
So how do we get the stuff on the screen? Oh, it is up. Great. Thank you, and thank you for inviting me for the presentation. My brief summary is going to be from perspective from the startup and companies that I advise, and also my own startup just started, and from my previous efforts in my prior companies. So I look at it as steady bulldozing, really, of the patent rights, and I'll explain why it is from the perspective of startups. There are obviously legitimate concerns about patent litigations, but when you actually look at things in perspective, when you look at the last century of patent litigation, but you look at it normalized by the commercial activity intensities, you actually find that we have much lower litigation rates in the 20th century, the latter part in the 21st century, compared to what happened in the evolution of electronics, petrochemicals, and some other industries, radio and others, in the early part of the 20th century. And this is a percentage of all civil litigation. Civil litigation should be a proxy for commercial or scale of activities and disputes. And so what we see is indeed a sharp rise, but it's really an artifact of the AIA, which is what Jay was talking about. The non-practicing entity business rationale didn't really change that much in 3 years, but what did change is the law. So let's keep things in perspective. Even if you look at it from another normalization, GDP, the real GDP, and you can look at other IP litigation. Don't look just at patents. You'll find that trademark and patent litigation similarly are much more growing in terms of the ratio to the GDP. So we basically have an unremarkable evolution, and the spikes that we see are really related to other factors, not real factors in terms of scale. But there's been a steady erosion from the perspective of small entities of the patent protection. What do we see? The America Invents Act fundamentally changed the grace period, something that was raised earlier with Congressman Issa about the grace period for public use and on-sale issues. It also established the post-grant review proceedings to challenge patents at the Patent Office. But ever since that, you could start seeing in 2014, essentially a death squad of patents at the PTO, because some of the way the law was interpreted allowed the PTO to essentially deny, in most cases, amendment of claims that would otherwise have been available had this prior art piece was considered and available for amending claims. That's a major issue. It's a threat to the well-being of patents. Inability to amend is a problem. Supreme Court also had muddied the waters for patent owners and also for those applications in the Patent Office. There's conflation and uncertainty on what is a patent-eligible subject matter. Big uncertainty specifically after Alice. and the Octane Fitness decision about if de facto loser pays is already in place judicially. All of these things have made it easier to challenge patents and made it harder to assert meritorious claims. And in the process, essentially causes a lot of people in the small businesses to reconsider the position on terms of patents. Most strikingly is the fact that when you go to court today, after Alice, you find that there's a big change in terms of the percentage of cases in which patents are ruled invalid. And that's a huge rise in invalidity of findings in the federal circuit, in the district courts. The IPR at the PTO is already at 80% kill rate. In other words, 80% of cases are being, or claims are being canceled. So what is a prospective patentee to do? What kind of promise does this give him to go forward with patent protection? Despite all of these, we have additional promises that we'll actually fix it even more. And I'll just talk about two cases. The fee shifting, for example, loser pays. It awards attorney fees to the prevailing party, and that is essentially effective loser pays. But if the loser can't pay, if it's not solvent, guess what? A party that is identified as real party in interest, more than 5% interest in a company, can be joined to cover the losses. Now, if you were an investor or if you were a startup, good luck in getting an investor who would agree to be joined in your case. That's essentially a death warrant for investment in companies. Party asserting a claim who later settles and extends a covenant not to sue is deemed non-prevailing party. Well, what does that mean? I'm not going to settle. If an offer is offered, and it will actually deny opportunities for settlement because I would basically be a loser by settling. Okay? Not intended consequence, but we'll get more lawsuits going to a trial. So that's one thing. The one-sided barrier against patentees is very plainly seen. So even look at the asymmetry in the provisions that are offered to fix things. For example, the heightened pleading standards for claims requires pleading with particularity, its claim, the infringing device, and so on. As Congressman Issa said, no longer will we not know what is being alleged. And he said we won't water it down, but it's already watered down on the other side. There's no similar requirement if you're alleging non-infringement or invalidity for you to show where's the prior art, why is your product not infringing, the same claim chart the plaintiff has to make, you don't have to do. You could just raise your hand, sorry, I'm not infringing, tough, I'll do discovery and we'll figure it out later. Asymmetric, fundamentally. Now the joinder concept, well, that's just to get more clarity, right? It's more to know who is behind it. Well, it's really in order to drag them in as a potential liability, and there's no requirement for a real party to join a real party for a declaratory judgment. So if you challenge a patentee and then you lose, I can't join your investor. You're going to go scot-free. So investors will have more incentives to invest in infringers. So these concepts are really inherently, facially asymmetric. Okay, and you can't perceive them as a patentee, but anything as is going after patentees. So that is the problem. So the enduring patent rights are being extinguished through the process. We have a piecemeal erosion of patent rights. They become a fixture in every session of Congress and any decision of the Supreme Court. There's uncertainty harm, even if the legislature doesn't pass. We've seen this during the process of AIA and after the AIA. These things are harming people in terms of the perspective of what to do. Make investments or not. Get a patent, spend the money or not. A lot of them, and I advise some small companies in terms of what they do, the patent bargain is no longer a bargain. It is basically less credible because we don't know what's going to survive in 5 years, 10 years in terms of the patent law. And we're going to make a disclosure now so the public can benefit, and we may or may not get anything. People are now looking at ways to shift the business model, and if we have time, I'll explain what I do in my company in terms of the trade secret approach. I already gave up on patent rights. So that's thank you.
Thanks, Ron. Our second speaker is Diane Letelier. Am I pronouncing it right?
It's just Lettler.
Lettler, okay. Who's Senior Managing Counsel for JCPenney Corporation, responsible for all patent litigation involving the company. She joined JCPenney in 2010 after 26 years in private litigation practice, where she focused on intellectual property litigation. Diane has represented patent owners asserting patents against competitors, defendants accused of infringement by competitors, as well as clients accused of infringement by NPEs.
Good morning. I want to thank the Technology Policy Institute for organizing this event. I think it's an important opportunity for me to address some of our view on the need for patent reform and from an industry perspective. JCPenney is a member of a broad coalition of companies that have been severely impacted by the proliferation of abusive patent litigation instigated by non-practicing entities. The coalition includes a broad spectrum of companies, large and small, and everything in between, representing virtually every sector of the American economy. The coalition's membership includes associations of retailers, home builders, realtors, restaurants, hotels, auto and convenience stores, as well as a wide variety of technology companies. The coalition's membership includes companies that own patents and seek to acquire new patents, as well as companies that license patents and technologies from others. Legislation targeted at abusive patent litigation is important to all of our member companies because we are each facing significant numbers of abusive patent claims and lawsuits year after year. The unprecedented costs incurred by our businesses to defend against these claims over the last decade is simply unsustainable. JCPenney is a century-old company that, despite selling a wide array of products and having extensive business operations and processes in place for decades, did not experience problems with patent litigation until the last 6 or 7 years. For the last several years, JCPenney has experienced dozens or more active claims at any one time, forcing it to spend millions of dollars in defending. These claims do not relate to the items that we sell. These cases relate to the technologies we use in our business processes. JCPenney's experience is not unique. It is common amongst retailers as well as other industry groups. In fact, many have experienced worse and spent more. Over the last decade, non-practicing entities have developed a litigation model that leverages the huge cost of defending infringement claims in order to obtain licensing fees that are strategically priced relative to the cost of defense. These extortion-type settlement demands are invariably about the cost of defense, not about substantiated claims of infringement or the value of the technology claimed in the asserted patents. The coalition is seeking to reform aspects of the litigation process in order to address some of the asymmetry that currently exists. Targeting areas of abuse will discourage frivolous claims and allow those accused of infringing a fair opportunity to defend themselves. For example, we're seeking transparency in the demand letters, clear notice of the accusations of infringement at the time the litigation is filed, and rationalizing the discovery process both in terms of cost and time. There are many statistics bandied about the proposition that the abusive patent litigation is a myth, and what we're seeing is somehow normal, and therefore no reform is needed. These statistics are the result of a selection of strategic data points in order to support a particular viewpoint. There's been a substantial increase in the litigation that companies are experiencing. And in the words of Bob Dylan, you don't need a weatherman to tell you which way the wind is blowing. And that is, we can all use statistics in various ways. I can use statistics that say that between November and December of 2014, there was a 32% increase. Someone else can use a statistic that says in September of 2014 compared to September of 2013, there was a 40% decrease. And I can say in March of 2014, there was a 25% increase over March of 2013. You can select how you slice and dice the numbers to support any viewpoint virtually in this debate. But I'm here today as a voice for the companies that are on the front lines, fighting these battles day in, day out, year after year. JCPenney and other defendant companies, for us, it's not a theoretical exercise or an empirical study. It is a harsh reality that diverts vast amounts of cash and resources from our core businesses in order to satisfy the growing appetite for cost of defense settlements sought by MPEs. And just on the whole definition of trolls, from our coalition viewpoint, it's not really about the very nature of the entity itself, it's about their tactics. And I like to refer to it more as troll tactics as opposed to a troll entity. And it's not unique in litigation history. We've experienced that in other forms of abusive tactics in other types of litigation, and steps have been taken to remedy that. And we're asking for remedies to be enforced in this context in order to bring balance back to the judicial process. Thank you.
Just a quick question before we move on. I'll ask questions later, but Diane, normally people don't expect to see retailers as part of the patent issues. Maybe in this room people do, but I think more broadly they don't. And you gave examples that it's the business processes you use. Are there some specific examples you could give of lawsuits that you've had to deal with that sort of illustrate the problems that retailers face?
Sure. I mean, we've experienced litigation both in the context of e-commerce platforms, but also in internal processes. We have experienced lawsuits that deal with the Ethernet capabilities of every machine used in our business. Just about virtually any type of system or process in place from point of sale to the e-commerce platforms have become an issue.
Okay, thanks. All right, next we have Lori Self, who is Vice President and Counsel of Government Affairs at Qualcomm Incorporated, where she specializes in intellectual property and related policy matters. She represents the company before Congress and U.S. government offices and supports Qualcomm's strategy and initiatives to promote strong intellectual property rights in China and other emerging markets. Prior to joining Qualcomm, she was a partner at Covington & Burling, where she chaired the firm's intellectual property practice group.
Thanks. Thanks very much for having me here today. And I wanted to say a special thank you to TPI for organizing the first panel. I think it's so important, no matter how you view the data, I think it's so important that we have a robust conversation about what the empirical analysis tell us, because the fact is that for a number of years, this policy debate has been driven by certain statistics that have kind of captured the imagination of the media and policymakers, and it's really important that we take a hard look at the economics behind these issues because the stakes are so high. One of the things I'm always struck by when I participate in panels of this type is that you are hearing two very legitimate perspectives. Ron's perspective of the serial entrepreneur dependent on patents is very much the perspective that Qualcomm brings to these issues. At the same time, the perspective that Diane has articulated in terms of being a target of abusive litigation is also a perspective that we can be sympathetic to, because the reality is, as a large company, our patent litigation is universally on the defendant end side of the divide these days. We are a defendant in approximately 20 cases a year. We haven't brought a patent case in many, many years, and that's in part because of the fact that we are a mature company with a well-established portfolio, and we don't have to resort to litigation in order to persuade licensees to come to the table. But the reality for small inventors is quite different. Because we do see this issue through both sides of the debate, we try to bring that perspective to policymakers and to ensure that any litigation reforms that are ultimately introduced, passed into law, do not create the asymmetrical effects that Professor Spelber was describing. And candidly, that is the concern with the Innovation Act that's been introduced in the past couple of weeks. As many of you, I'm sure, know, it is the identical bill that passed the House in 2013. And politically, I think there's a lot, it's perfectly logical that the House Judiciary Committee would move forward with an identical piece of legislation that had such an overwhelming vote of support in the House in 2013. The reality, though, is that very few members of Congress actually understood what they were voting on. And over the past year, there's been a great deal of effort by a broad range of groups, I think representing the patent-owning community, to come to the table and say, look, all of what you're describing in concept makes good sense. Heightened transparency, more efficient discovery, clarity around fee shifting standards. All of those concepts could, in fact, lead to disincentives against abusive conduct, but if implemented in a way that is overly broad, that is that essentially makes it impossible to enforce a patent, no matter how valid, no matter how meritorious the suit, then you are creating far more problems than you're solving. And I think those concerns have been articulated by other panelists. That's a concern that Qualcomm shares. We do look at these issues through the lens of a startup that we once were in 1985. We want our startup economy to continue to flourish, and we see patents as being critical to that dynamic. The comment was made in the earlier panel that we have other forms of protection. We feel very strongly that trade secrets are not a perfect substitute for patents. If you think about how the mobile ecosystem has flourished over the past 30 years since Qualcomm was founded, it was in part because companies like Qualcomm made the decision to license our technological developments broadly. You cannot achieve that kind of collaborative ecosystem, competitive ecosystem, through trade secrecy, by building walls around your technology. So we think the stakes are high. We recognize that there are legitimate problems that have been raised by those companies like JCPenney that are pursuing patent reform, but we think it's imperative to the health of our patent ecosystem, to our innovation economy, that we get the balance right. And it concerns me, candidly, when I hear Chairman Issa say, no changes, we're going to rush this through, because it means that the full array of very legitimate perspectives, economic concerns, interests are not going to be allowed to influence the way this bill moves forward. So our plea, if you will, is that the Senate, that if in fact the House does rush to judgment, as Professor Spelberse indicated, that we have an opportunity in the Senate to get this right, because the stakes are too high to get it wrong. And so with that, I will close.
All right. Last in alphabetical order, and I empathize with that being a W. I always feel badly for the Z's in such a list, although I'd love to be a co-author with you, since my name. So Danny Zadoff is the co-founder and managing partner of Nutritionix, which he co-founded in 2010. And under his leadership, the company has become the world's largest and most accurate nutrition database and the industry standard for restaurant nutrition calculators. Today, Nutritionix powers thousands of fitness and diet applications with its robust database of over 400,000 food items, and also provides restaurants with the nutrition information they need to empower their customers to make informed decisions on their diet. Danny.
Thank you very much. What I want to do today is give you the other side of the coin of what an inventor or an entrepreneur feels on this subject, where there are many valid points being shared of how an inventor may feel afraid to be able to stand up with their patent. And as a company that has 2 pending patents, I want to tell you our quick story, how our patent troll scare happened, and then in the Q&A, we'll dive a little bit deeper. So in 2010, we started Nutritionix, and we developed something very simple. It's a calculator that just adds and subtracts nutrition information from foods and restaurants. So a customer can go to Chipotle, build their burrito exactly how they want, and know what it is. We started selling this product to all different types of restaurants, and it was growing in popularity very quickly. As we were selling to some of the brands, they started mentioning to us this fear of a patent troll, which we had never heard this term. We were fresh out of college, created a company, and didn't know that someone could patent an idea of math, just a very simple idea. And time and time and again, we would get very far along in the sales process, and clients would decide that they didn't want to proceed with us because of the fear of a troll. And over the years, this started to really affect our sales. We started to have a big decline, leading all the way up to April of last year, where we had to start laying off employees, and our revenue decreased significantly. In this time, as part of the Affordable Care Act, there was a part that the FDA needs to put calories on menu boards on all restaurants over 20 locations and provide a full breakdown of the nutrition information when a customer requests it. Now, for a pizza chain, there's millions of combinations of how you would show the information, and the only way of showing that is through a nutrition calculator. So we had this interesting part of a huge demand from restaurants, but the fear that they wanted us to indemnify them for them to prepare for compliance on another government stipulation. So while we completely look forward to in December 1st of this year when the information will go live, these restaurants would start asking for the indemnification, we would provide it, and when we tried reaching out to the patent troll asking if we could get a license for the patent, they made it very clear they had no interest in licensing it to us to actually sell our product. They only wanted to wait, and every time we would sign a new client, they would wait to poach them to sue our clients with the case. We started looking into our law firm of what we could do to better understand this, and the legal bills were increasing very quickly. Just as a frame of reference, to get a letter that would explain to our clients that we were not infringing, do research into prior art, it was going to cost roughly $25,000, which at that time was a quarter of our revenue. Not the kind of money that we could spend just to prove that something wasn't going to be infringing when it was so light. Over this period of time, we calculate that we've lost roughly 19 different clients for roughly $1 million in sales. And the greatest news was that we got very, very lucky that our patent was overturned, because our patent trolls, patent, very, very, whew, that was close. But the key reason there was because they sued huge restaurant chains, Google, Time, 17 Magazine, Bravo, and it was because they had the deep pockets to be able to fight all the way through court, where if we were actually named in this suit, we would have gone bankrupt well before ever getting to the courtroom. The main piece that I want to get across today is the fear that we lived in every day of running a company, of trying to keep our heads down to not ruffle any feathers, of people not knowing that we were providing a product that could easily get us into a suit that would put us under, even though we knew that a patent like that wouldn't be able to stand. Once it was overturned, we went to all of those old clients. They started signing on tremendously. We've had huge growth of doubling in revenue, doubling in employee size. Everything has been going incredibly in the last 8 months since then. And the main thing is that we were a very rare scenario that we got lucky. It's a small segment of the patents out there that Alice would be able to help out, even if we had the money to go all the way through. But it's the vast majority of companies out there that are still potentially liable or can get into this kind of a legal issue. Over the last few years with the Developers Alliance and with the Coalition, they've asked us to speak in a few events, and it's always been behind closed doors, whether it was in the House or Senate, because we were too afraid to be in public. Right now, we have the luxury of not having a patent troll coming after us, and we know that it's the time to act to actually get change, because any patent troll can come around next week with a new patent, and for all the other companies that don't have the luck that we had. Thank you.
Danny, let me ask, what was, when you first, when potential customers first came to you with this fear, were they already able to identify a specific patent, or was it just a general fear? I mean, we know it was a specific patent ultimately, but did they already know? They said, oh, look, we think you may be violating this patent, and you're going to be, there might be a problem, or were they just worried in general?
Coincidentally, since they had the patent troll in the first suit named, I believe it was 35 parties, of those parties were the very large ones that did have the funding to do all this. So there was a lot of publication already out explaining what it was.
I see, okay. So I should give everybody a chance to respond to each other. But first I want to ask, Ron and Dan are both sort of representing startups. And of course, we can learn a lot from the cases. We know from Professor Tucker's excellent case studies on the effects on innovation. But why are your experiences so different? Is one sort of more typical of startups, do you think?
Perhaps I can preface what I'm saying. In my first startup, when I started, the first thing we did when we looked at what we're going to develop is study the competition, look at the kind of patents they have, did some analysis of freedom to operate. To some degree, that analysis, that research, actually made our product even better. And so we weren't just jumping into something hoping nobody would sue us. We took the function of the notice function of the patent system very seriously. Patents are presumed valid. And so when we looked at these patents, we looked at the claims, to the extent where we thought, well, some of these things are weak and we knew we may not be able to challenge them. We did a lot of design around work. And it turns out that when you make that investment and you document it and you work through, you can be a lot more comfortable in putting out a product that is arguably and potentially more forcefully non-infringing. To the extent that patents are invalid, and some of these claims seem to be pretty broad, it sounds like I haven't looked at it, there's prior art to it. And so we verified that certain things that are in the claim, prior art, we were doing prior art elements, and so we were comfortable. That discipline of freedom to operate analysis is essential. And if you look at what investors are going to look at, they want to ask you, have you done that? Can we see some of that? And can we see evidence of it? Normally, we wouldn't share with them our analysis, but we would show them what we've looked at. So we looked at these patents. We're not going to make all representation. The point is, there's a very important function of the patent system that seems to have been glossed over, and that's the difference, perhaps, between us.
Mm-hmm. Danny?
I think the key part there is that we didn't just frivolously enter the market without looking to see if there were competitors. It was a simple tool to put together different numbers of foods. When we were doing our research on what was out there, it was widespread that this was being used, and when we did do the prior art on this specific patent, once we found out who the troll was, it was for a picture-based meal builder that was very specific, that there had to be images of the product showing a hamburger, and you would select it and add it to a meal. Our product doesn't do anything close to that. You can, through text, build a tool or build a meal. So we knew very clearly we weren't going to be infringing, but the problem was these broad patents, this is what the trolls live for. They're going to expand every part of the claim and go after someone like a magazine, random things that don't even have, like a restaurant that has the food to do it. So we knew that even though we were in the right, we could be sued very easily. And if that happened before the discovery phase would be even halfway through, we would have already gone bankrupt.
If I could just kind of add a different angle to this whole debate, is as a adopter of technology, we historically, as a company, dealt with innovators all the time. We have a rich history of even accepting cold calls from startups and small inventors that have an idea that they're looking for that first big break. And JCPenney has a rich history of working with them to further their innovation, to test out their innovation, to give them feedback and help grow that innovation, because we viewed that as a value to our business. I can tell you that in the last decade, we have had to shrink that entire engagement process because of the troll factor. And when I sit down and I'm talking with innovators about an idea they have, small companies, startups coming to us with an idea, we always start talking about patents. And when I ask them, do you have patents related to this technology? I never hear back from them, no, because we don't believe patents have any value anymore. We don't believe that patents are worth pursuing anymore. I never hear that. But then when I ask them about indemnification that we need some protection, that if we engage in their technology and in use of their technology, that we are then not going to become the victim of the trolls. Because in fact, that's been our experience in the last several years. So, I mean, innovation is two-sided. Innovation without adopters goes nowhere. So that is why we are seeking reform, so that we can bring some balance back to the process, so that as a company that wants to engage and adopt good technology and help the innovation process, we have the freedom to do that without this this relentless fear of trolls, for which we really aren't infringing. We've never been held to infringe in all the cases that we face. But the sheer cost of defending yourself stymies our ability to engage with innovators. And that's innovation not just from small, and it's not big companies, it's the small companies that we recognize. Small companies usually have some of the greatest innovation, and we would like to engage with them. And we would like to coordinate their innovation with licensing technology that we have from other companies. We want to build that. We want to continue that rich history that we have. And it's just really disappointing, and it's really hard as a business to say that's a great idea, but we can't afford to engage in it.
So can I weigh in? So I think that, again, part of the challenge of this debate, if you will, is that a lot of the conversation is sort of taking place at a 30,000-foot level, and whereas the conversation really should be taking place at a more kind of granular level of, is this legislative proposal actually a solution to a real problem? Because we know that there are real problems. We also know that there are very serious risks of unintended consequences if we craft legislation that is overly broad or hurts small inventors, you know, in the process of trying to solve problems for real legitimate adopters. And I think, candidly, from our perspective, one of the real challenges that we faced with this, you know, latest iteration of patent reform is that there hasn't been what I would consider to be a serious opportunity to engage in a really technical conversation about, okay, we're going to heighten pleading. Does this legislative language actually provide the notice that a company like JCPenney or a small company needs to understand the nature of the allegations that are being made against them without creating unnecessary costs, landmines, if you will, for legitimate inventors who may be forced into litigation because a big company refuses to come to the licensing table? And those are really difficult conversations. I mean, there have been decades of debate within the Judicial Conference, which is the kind of policy-making arm of the judiciary, over pleading requirements, discovery requirements. These are, you know, highly technical issues that really do require a very serious discussion. And again, I think the dynamic that we've seen in the House is one where, for political reasons, let's just get this bill through as quickly as possible. Let's just get this 60-page sweeping piece of patent legislation through the House as quickly as possible so that nobody really understands what they're voting for. And that can't be the right answer to such, you know, a highly important area of our law, our economy, that's going to have, you know, consequences for a huge array of small inventors, large inventors, adopters, et cetera. So again, I don't dismiss anything that's being said by Diane or Dan about the problems that are confronting small companies, adopters, but it's so important that we get the solution right, because, you know, we are really talking about, as it was said, fundamental changes to our system of litigation, and there's a version of that legislation that I think is balanced, that works for a broad array of stakeholders, but we really haven't had that kind of serious conversation about, you know, how we should be implementing the reforms that we're talking about at a, you know, kind of a high conceptual level.
Ron, I know you wanted to say something, but just let me ask quickly. Lori, do you think that groups like the one that JCPenney is part of, are they wrong in supporting the legislation because it won't actually help them? Or, I mean, it's the wrong, it targets the wrong things and won't help them, or because the costs of it are too high, even though it would address the issues that they are concerned with.
I mean, I don't want to say anybody's wrong or right, because again, we look at these issues through our own perspective based on our own experience. But, I know, for example, Diane and I were part of a discussion that took place last year over the customer stay provision, which is one part of this bill that we have very serious concerns about. Again, the purported goal is to kind of, immunize, if you will, the small companies, the kind of, retailers at the end of the stream of commerce from litigation when there is a manufacturer who is a more appropriate target for that litigation. But the way the provision is now crafted, and again, this is, there are lots of, you have to consider the fact that in every litigation you have a unique fact pattern that is going to dictate whether or not a stay makes sense or it doesn't make sense. And these, what we see is sort of a pattern throughout the legislation that's been introduced in the House is this kind of one-size-fits-all approach to litigation that, even with that one provision that could have profound consequences for a company in our sector versus, a retailer. So I think part of the challenge is that until you really dig into the legislative language and sit down with different stakeholders from different parts of the economy that are going to be impacted by this bill, you don't fully understand what the potential implications are for the retail community, the small inventor community, the large inventor community. And my concern is that we're trying to create this sort of political momentum to push this bill through as quickly as possible, that we're not going to have that kind of a conversation. And we should have that kind of conversation. I mean, the AIA, a lot of people, it was a 6-7 year process to get the American Invents Act through Congress. From my perspective, that was a good thing because it allowed a very large group of stakeholders to come to the table and express concerns. And it also took account of what was happening in the courts, the judicial conference, our economy generally. I think whenever you ram through highly complicated legislation of this type, you're going to create unintended consequences for both, for all sectors of the economy. So I don't want to suggest that anybody's wrong in thinking that this is going to solve a problem. I just don't think we've had the kind of robust debate that we need to have in order to understand whether what's been tabled is in fact a solution to a problem or instead a contributor to a whole new set of problems that have not been fully explored.
Okay. I'd like to make one more point about the scale in terms of something you haven't seen only in the last 10 years. JCPenney has seen more of these assertions. If you recall my chart showing the huge litigation intensities in the early 20s and 30s, there are a lot of vendors and companies who didn't think that they should be sued, that were sued on new technologies that were developed, electronic tubes, vacuum tubes. People who were making sets and all of a sudden some patentees come over and sue them on vacuum tubes they didn't make. They just use it with some devices. Those are, pretty high number of suits at the time. It comes with a turf of new technology, the uncertainty that comes with it in terms of the defined terms and claims, in terms of what's infringing, what isn't, in terms of different players that were never part of the ecosystem of the industry before and probably are using other means of trying to enforce their patents. And we've seen that at those times. And similarly, some concerns have been raised during that time. The TNEC Commission in the late 30s met and talked about these things. But there was no thrashing of patent law to the extent that we see today. And that is something that to me, these are problems. They can be addressed. But to the extent that somebody is bringing a frivolous suit, to the extent that they're not making particularized allegations, that's a general issue that will come up in commerce, in tort issues, in commercial civil litigation. Why should there be a specific solution to the patents problem when the issue is really a specificity of pleading that is important on both sides? Those who declare or want to get a declaratory motion, they wouldn't have to put all these specificity. I'll ask you now, would you have a problem Diane, if the issue of pleading would be symmetric. In other words, if you're going to plead for declaratory judgment, saying that I do not infringe your patent, and your patent is invalid, you'd have the same burden of pleading in particularity your point. Would you like to see that change? Because that's not in the bill now.
Well, I think by definition, that's somewhat difficult because in seeking a declaratory judgment of non-infringement, you're proving a negative. So I'm not sure how you would chart the negative. I guess the chart would be,
You assert invalidity
I'm sorry, you said non-infringement.
and invalidity. There's two components typically in those declaratory judgments. And invalidity too, yes. I mean, you have a claim, and you have an item that you own, and you say, I don't infringe that claim, and here's why. This claim says this, but my stuff does that. This patent is not valid because there's prior art on this claim, and this is why. Particularity is symmetric on these allegations, aren't they?
I'm not sure I quite followed the last point, but I mean, that has not currently been proposed, and no one has proposed language with respect to that. I think to the extent that someone is seeking a declaratory judgment of non-infringement, again, you're proving the negative, the absence of something, and that's hard to do in the chart format that is suggested in the...
What about invalidity?
In the context of invalidity, I mean, someone could propose language as to what that would look like, and we could consider that. Right now, I've not seen any proposal for that, and I've not heard anyone voice opposition to that. And in fact, in the current process, there comes a point in the litigation in which you are required to do that. And there is an asymmetrical requirement with respect to that is very harmful to defendants in litigation. So to suggest that defendants never have to specifically allege their prior art or how it establishes that the patent claim is invalid, that's not correct. In fact, in most of the courts that handle the vast majority of litigation, there is a requirement that you produce very specific allegations of invalidity.
But not in a complaint. But not in a complaint, right?
Well, I'm not filing a complaint because I'm the
Well, but
defendant.
you want to see a particularity at the phase of the complaint on the side of a patentee, but not one in terms of those who file for declaratory judgment that the patent is invalid. And that's the symmetry. Now,
Well, if I could just say, I mean, right now, I've not heard anyone say that the fact that there is no detailed pleading of invalidity at the time of assertion of invalidity, as opposed to later in the charting process, that has caused an imbalance in the litigation process. But, I mean, certainly if someone wants to propose...
that. We have proposed that during the HR 3309 litigation, and we were basically rebuffed. So the specific language was offered to make it symmetric, and we were rebuffed.
Well, and part of it is the timing. So, for example, in the context of litigation, when someone files their patent infringement claim, and assuming that legislation passes that requires particular identification of the claims asserted and the patents asserted and the claims asserted, then a defendant only has 20 days to respond. So a patent holder can time their filing and prepare all of their work and time it when it's good for them. But then I only have 20 days to respond.
Yeah,
That's not even enough time to do the prior art search.
I didn't talk about a defendant. I'm talking about a plaintiff asserting a declaratory judgment which had time to prepare to say this is an invalid patent and I don't infringe. He is the plaintiff. You know, patent cases are not always plaintiffs, are not always patentees. A lot of times they're alleged infringers. And they have time to prepare these declaratory motions and to make the same particularity assertions that they're making. We just don't see it in the legislation.
Well,
And we tried, and we were said no.
okay, well, that's different than when they are asserting it as a defense. So,
No, I agree.
okay, so if you go back to where I am a declaratory judgment plaintiff,
Correct.
part of the problem with that is what generates some of that declaratory judgment action, which by statistical measure is a very small fraction of cases that are pending relating to patents. Very small fraction.
Do you know the number?
No, I don't know the number
It's
off my...
20%. I know the number. I looked at
That
20%,
initiate as a...
20% of lawsuits are declaratory actions by would-be defendants. 20%.
So I think this proves my
Well,
point
if I could
that
just-
these are highly complicated issues.
Okay, well, frankly, I don't think that is a correct statistic, but we can debate how you counted that. But going back to the initial point, part of what generates a declaratory judgment in that sense is that you receive a demand letter that does not identify what claim you supposedly infringe, does not clearly identify how you infringe it. So to give a specific chart for what claims are invalid when you don't know which claims they're actually going to assert, it gets very much in a chicken and an egg scenario. So while I'm not opposed to the concept, if I received a demand letter that said you infringe claim 1 of this patent in this way, I'm not opposed to being required, if I decide to take a declaratory judgment step to say this action, this patent is, claim 1 of this patent is invalid because of this prior art, I'm not opposed to that.
Okay, but that's what the law proposed. The law now proposed that particularity, so clearly, if that's in place, you would not oppose to then putting the burden on declaratory judgment people, because that particularity is required in demand letters. If we have this legislation passed, the demand letter requirement would essentially meet the concern you have in terms of particularity of the assertions.
If
But-
they comply.
Yeah, yeah.
But
yeah.
there's also a lot of gaming
Yeah,
that
and-
still, I mean, because let's not pretend that this solves all problems.
No, I agree. And
I mean, because
and
I
they have
have-
to comply. They have to comply, and if they don't, then the burden on those who filing declaratory judgment has to be relaxed. I agree.
So, yeah. So I was just going to say that, I mean, again, on something like pleading, which is just one component of a multi-component bill, I think what I hear from a lot of, folks in the patent owning community is, yes, we agree that we need to move away from the current system, which is a kind of a bare bones notice pleading system. But I think what this conversation is really speaking to is, okay, what do we replace that with? And so when Qualcomm talks about, the overbreadth of the current Innovation Act proposal, we see the pendulum swinging from, a bare bones system, which I think does create the kind of problems that Diane and Dan are alluding to something that is at the opposite extreme, highly prescriptive. I mean, there are certain disclosure requirements in the proposal that candidly can't be met because they just, I mean, I don't need to go into a lot of details, but they don't make sense as drafted. And so, what we're advocating for is kind of moving the pendulum back in more of a balanced direction so that you are putting an onus on the patent owner to make meaningful disclosures about the nature of the infringement allegation, but not creating a kind of a, obstacle course, if you will, for patent owners so that the mere act of pleading becomes a roadblock in terms of your ability to enforce your rights and a potential source of even more litigation cost and delay. Chairman Issa talked about we want to make sure that, we have swift access to court and swift resolution of these cases. Well, what we see in the framework of many of these proposals is something that will increase litigation costs considerably, uncertainty around litigation. We're going to see years of litigation just over what these different requirements mean. So I think there is a compromise position, but again, it requires, expert minds, experienced litigators to come to the table and really craft something that makes sense. And we haven't had that kind of a process yet.
And I think that the first step of talking about that there isn't a balance with the new versions, what you're saying, Ron. In the current version that we have right now, it is so far swung in the other direction, like we've all discussed, that as the entrepreneur, this change can't wait, unfortunately, 7 years like it did with the previous one. It's something that needs to happen in the short term to keep America inventing. Because as an entrepreneur, if I would have known all of this 5 years ago, my co-founder and I have said very clearly we would never have started the company and we wouldn't have done it. It's just not worth the risk of putting your entire life investment and time into something that one troll can ruin in a weekend. So for us, I agree that there are certain parts that should be expanded on. Like the PTO is doing a great job already of how they're looking at new patents applications and how they'll be approving. But there is the last 20 years of ones that have been already accepted that are somewhat broad and can cause a lot of this issue to occur. So it's something that we need to do something for the short term to make sure that we keep everything going properly.
Yeah, and I think one thing I would love to hear, you know, from the adopter community, from the small business community is, you know, what is that one thing that in your view would be most impactful? Because right now we have sort of the kitchen sink version of litigation reform. You know, to your point about would you have made the investment? Well, I think a lot of small inventors are now saying, do I want to make that investment, knowing that at the end of the day it's going to be virtually impossible to enforce my rights in court. And the other consequence of that, if you can't enforce your rights in court, you're never going to be able to get a big company to the negotiating table. I mean, and that's something we have to keep in mind as well. As we fundamentally change the you know, balance of power, if you will, in our litigation system, we are fundamentally impacting the leverage, if you will, that a patent owner has to persuade somebody to voluntarily take a license. So that's a you know, kind of an unintended consequence, if you will, that we really need to keep in mind here. But you know, I think again, having a conversation about what aspect of the current dynamic is most problematic, is creating the greatest incentives for abuse. You know, what targeted changes to our litigation system can we make to reduce those abuse incentives? I mean, I think that's a really constructive conversation to have, and you know, really helping, you know, if we could help bridge this divide by having a conversation about what will have a positive consequence without creating all of these unintended consequences, I think that is really the kind of, you know, debate that we should be having, as opposed to this, what seems to be this kind of clash of, you know, us against them, because it, you know, look, we're all this is really about our economic and competitive health. It shouldn't be a win or lose proposition here. So anyway, I don't know if Diane or if you have any thoughts on that. But
We should probably, unless you have something quick, we should probably take questions from the audience, or unless it's, so there was, yeah, you were right there, and then over here.
Yes, I have a question for the four panelists, Ron, Diane, Lori, and Daniel. Daniel, I'm very empathetic to what you said, because at my practice, I'm not a litigator. I started as one. And I'm empathetic to your problems. I can tell you 24 startups that I brought to a viable entity, none of them have been sued over a patent. Every one of them tells me they would never do it again, because it's getting so difficult to protect and to grow the business and bring in venture capital. I wanted to share with you the first 2 years of my practice when I was a young lawyer. I worked on a case for a large corporation that sold an end product and had a supplier chain. Our client was one of the suppliers. And I did the document discovery. And in those rooms full of documents, I found our client's drawing with the title block blocked out. And it had been given to the competitor, who was high volume, low cost. And they were told, you supply it to us cheaper. So my question for each of you is the following. There are people that steal things, and they're not patent trolls. In your industry, I don't want to know in your company, but in your industry, do you have a general sense of what percentage of patent litigation that you see is not abusive patent litigation?
Well, if I could address that first, I mean, what we have had sporadic claims related to products that we sell, that are really kind of more competitors, where a competitor has, obviously we didn't produce the product ourselves, but we bought it from someone and then we sell it to the public, where there's really a competitor dispute as to whether or not a particular product may be covered. We don't consider that any part of this issue. And those have been very, very isolated and sporadic. I can tell you in the cases that we have experienced, which we kind of put into the bucket of the problem litigation and the abusive litigation, there was not a single instance in which there was a claim of a theft of the idea. And we do believe that there are valid patents out there. We do believe that infringement has occurred in certain instances, and that patent owners have to have the access to courts to enforce those patents. That is not what this debate, from our standpoint and from the coalition standpoint, is about. The problem that we are focused on is really ties well with the example of the nutrition calculator. There was a patent that dealt with, you had this image and you selected the image and you put it into your little collection of what you were calculating. And you heard him say, our process didn't have anything to do with images, but the patent was being asserted regardless. That is the core of the troll patent. And in the prior example, and I think you were the one that threw it out, that they had a patent and they sold it and then it gets asserted and it went from being a good patent to a bad patent. The character of the patent did not change. What changed was the character of the assertion. Patents, by definition, are granted on a very narrow slice of technology. Very rarely is a patent truly transformative in an industry. There are very few patents that fall into that category. Patents are as they are stated in the claims. And the claims normally are on a very narrow slice of a bigger picture of technology. But what happens when they fall into the hands of the trolls is this very narrow slice gets then asserted against any participant in the entire package, in the entire circle of the technology. And that is the fundamental essence of the problem and why heightened pleadings, from our standpoint, is so important. Because it forces to the table the issue, wait a minute, my calculator doesn't use an image. Your patent claim specifically requires the use of an image. I don't have an image. I mean, that's what forces that to the top of the heap and it will advance, I think, a speedier resolution of litigation claims and I think would stop some of the abuse. Because right now they're hiding behind the fact, oh, we have a patent. That's all you have. There are millions of patents enforced. We have had more than 6 claims on just how we display an image on our website. All of them claim that their patent was completely transformative and how we do it falls squarely on their patent. Well, just in that, they can't all be right. Only one, even if one of them right, only one of the 6 can be right. So, I mean, that is the problem that we're facing. They will not stick to what, in the hands of the trolls, they take that patent, which is presumed valid, and then they assert it against this whole big bucket of activity. That is the core of our problem, and that is the core of the troll tactic.
So I don't know the percentage either of what the amount would be, but what I see is knowing that we're going to have our patents issued at some point in the future, I don't see any problem with having to do the new style of the demand letter, of having to put this additional information. Because if I'm filing a patent, I should be an expert in what I've developed. And for me to write down on paper, this is what my product does, this is where your product is copying it, here's the exact spot on the patent, shouldn't be a difficult process. And I look forward to doing that if I need to assert my claim in the future.
I'd like to make one comment. I generally agree with Diane's point. Is it Diane? Yes. Yeah. About the particularity, and I think it'd be nice to have it in most cases. A lot of times, though, depending on the technology, the patentee doesn't know exactly how the accused device actually implements. So he may not know the specific elements, and typically there's information and belief. Sometimes he doesn't have ability to reverse engineer that product. It may be sitting in a server someplace. Surely we know that in the legal system, pleading of a complaint doesn't assume that you know everything, all the facts of the accused device. We have discovery for that. And so the challenge is that while certain types of patent cases will go forward with these types of pleadings, they inherently be very selective to the type of technology. There will be things that are out there in the market that could be reversed engineered, and somebody can put together a claim chart. What we will see is essentially an evasion from potential liability of certain technologies that are hidden, that are not available immediately, and yet infringing. And to some degree, when I spoke about the fact that we are now motivated to think through business models that rely on trade secrets, it's a double-edged, it's on both sides. If I can't enforce a patent right, I may have a business plan, a business method that I'm no longer going to vend or make products that are readily reverse engineerable. They're actually hidden in a server someplace and are unavailable. And guess what? Nobody can find out what it is in terms of benefiting from it because I haven't disclosed it. And frankly, if there is an element of my device that could be alleged to be infringing, I've erected barriers for those who have to come up with these pleadings, and they won't be able to do it. So it's going to generate a chasm in terms of the technologies that are essentially going to be more readily invested in versus those that are not. It's going to shift. And when Dan was saying, be careful of what you're doing, we've seen the concept of the guilds, of the trade secret concept. It's a different type of technology that is being focused in that area other than open. So that's the risk that I think will happen here.
Okay, there's another question at that table. Yep. And then,
Yeah, Todd Dickinson. It's a lot of the debate has been framed recently as to whether or not we're seeing a fall off in litigation or not, and what that may be due to. The fall off seems to be pretty real. Professor Lemley at Stanford, for example, who supported the legislation, now says it's not needed anymore. And one potential reason, presumably, is what the AA did, which was to craft a post-grant system at the PTO, which allowed for a cheaper alternative to litigation in order to test the validity of patents. Given that the PTO in their IPR system now, 75% are granted or to initiate. In the early days, there was a significant invalidity rate. It's flattened out a little bit now, but it got to the point where I think Ron used the phrase death squad. And I guess my question is, maybe to Diane, maybe to others, in your 10s and 20s of lawsuits in which you're involved, have you used the IPR system? To what extent have you used the IPR system where the costs are maybe a 1/10, a 100th of the overall litigation cost in order to attempt to test the validity and invalidate those broad claims that concern you?
We have not filed a PGR proceeding at this point. We have participated in, we've been co-defendants, if you will, in consolidated cases where co-defendants have filed, so it's impacted some of our cases. But while it's almost an additional cost in some ways, so it's not as inexpensive as we had hoped the process would be. It clearly provides an inexpensive route to resolve potentially some invalidity issues, but you still have the infringement issue left over in the event that it is not invalidated, or if only certain claims are invalidated. So, and we're very early on in that process, and so we really haven't had quite the opportunity to use it in the way that we would like to use it at this point. But, and it's really early to say what the statistics will be on PGR. Overall, I mean, the early statistics went one way, but I think as the data grows in volume, I think you'll see a difference in those statistics. And you also have to remember that a company is not going to file a PGR unless they have a very high degree of confidence in the invalidity of assertion. So they are only looking at the most vulnerable patents in the PGR process at this point. So, you know, there's pros and cons to the PGR. It has worked well for some. We have not yet had we haven't been in the right posture to do what we wanted to do with that, and part of the consolidation of cases is part of the reason for that. But I will say, I think that while there was a percentage decline in 2014 over 2013, I do think part of that is because what was going on in the PGR process. I do think that overall, while we are at a very high level from a historical perspective. So to say that it's maybe plateaued this year, it's plateaued at a very high level. That doesn't mean we still don't have a problem. And we think that as these cases start to emerge from the PGR proceedings, that we'll see again a change in those statistics. But overall, we see the continuing need. We do not believe we should be satisfied that just because PGR has provided some relief to some parties for some instances, that solves all of our problems. We certainly are still getting demand letters. Litigation is certainly being filed. January and February have been very active months, and no one has seen those numbers yet. But just looking at some that I was watching, I mean, it's been a very active month in terms of filing. And so, and in the case law, a lot of people point to Alice as being a reason why we won't need patent reform. But the reality is, there were thousands of cases filed in 2014, and to date, my last calculation was there have only been 31 patents invalidated in district courts as a result of Alice. So it's while Alice is a powerful opinion with respect to a certain class of patents, it is overall a relatively small percentage of the pending cases. 31 out of thousands does not give me a lot of comfort that we have solved our problem. And I think the other thing that's key to remember about Alice is Alice didn't change the law. The 101 requirement of patentable subject matter was always there. All Alice did was redefine how you evaluate that process and the test for 101. 101 subject matter patentability has been there for decades. So it wasn't this fundamental shift in the law that people want to portray Alice was. It has been a valuable tool with respect to those class of patents. But again, you'll hear members of our coalition that say, they've got hundreds of cases, dozens of cases pending, and not one of them, even in their view, falls within the effect of Alice. So, there's a lot of work still to be done.
I think this has to be the last question, but right down here.
My question is about fee shifting, because I philosophically don't think it's a bad idea to have more information in complaints, but it seems that fee shifting is being portrayed as a panacea, that will be a critical piece of any solution, when in fact I can't personally figure out why that's going to do anything other than deter independent inventors, universities, and startup businesses from seeking to enforce their rights, because district courts already have the ability to award fees in the case of vexatious litigation. The Supreme Court's given them more deference, and even with the deference that they've been given more, and even if the Innovation Act passes, you still have to fight all the way to the end to be a prevailing party. And against virtually all trolls, the industry settles. So there will never be fee shifting if there's a settlement. So I am confused as to why anybody would say that's going to do anything other than harm innovators.
Gene, I think the harm could be symmetric in terms of defendants or patentees. It's essentially asymmetric relate to size. So for example, if a company is approached, a small company approached and told, you infringe our patent, for example, our speaker here, an example, under the fee shifting, if he is asserting a declaratory judgment action that says I'm not infringing and it's invalid, and he loses, he also has to pay up the fees to the other side. So this is a problem that singles out small entities, regardless of whether they're a defendant, whether they're alleged infringers or patentees. It's basically a filter of those who can't really afford to participate in the legal system. They don't have the money. Now, it's true, 80% of plaintiffs in patent cases are patentees. It's true. So it's mostly going to affect patentees. But don't underestimate the impact on those who are going along their way and having to assert non-infringement and validity, and they can do it. Now, the proposed legislation happens to favor them because you can't drag their investors in with this disclosure. Real party of interest is not required. In fact, in that legislation, you could see that that's, again, part of the asymmetry. So to some degree, dragging in real party of interest is only on the side of the patentee, not.
But you still have to prevail, and that means you can't settle. And we know that the industry settles against patent trolls.
Yeah, so the effect is I agree with you, the effect is mostly deterrent, but it deters both sides, not just one side.
Let me just say on fee shifting, before Octane Fitness, that was one of the provisions where we thought we were not in favor of shifting the presumption, but we were in favor of adding more clarity around the exceptional cases standard and potentially, lowering that bar to something more like the copyright standard that applies to fee shifting. Post Octane Fitness, I think there's a real question about why as you say, this is being kind of touted as the, linchpin, if you will, of litigation reform. But just to kind of give some background on how our thinking on this issue has somewhat shifted. So we actually we were involved in a case where we did pursue what we considered to be a frivolous lawsuit as a defendant, pursued it through a judgment, prevailed, and were awarded attorney's fees under the previous standard. Now that is by far, that is absolutely an exception, and we clearly felt the rarity of that event, and it was also kind of the quintessential scenario of the shell company backed by a private equity firm, and so at the end of the day, there was really no teeth to the award. So we favored some clarity around fee shifting. When we were in the 2013 time period before Octane Fitness, but when we started talking to small inventor groups, to companies in their infancy as opposed to mature companies like Qualcomm, we really did start to appreciate the dynamic that you're describing, which is, again, they see the asymmetries of litigation on the other side, where they are attempting to force their rights against a much larger implementer of their technology who puts them through every, litigation hoop available to prevent them from enforcing their rights in court. And what we were hearing is that if at the end of the day, if you don't succeed, and in any patent litigation, you can go in with the best of intentions and still lose, that would have been the prospect of having to pay the other side's exorbitant fees would have been enough to essentially scare their investors away. So I think on the fee shifting issue, we can, we did see the merits of having greater clarity around the standard and not having so high of a bar that the Federal Circuit had set. But we also understand, I think, having talked to so many universities and small inventors, that shifting the presumption, moving to the kind of standard that's now in the House bill is something that will have a really profound chilling effect on investments in early stage invention activities. So, again, I think with fee shifting, maybe there's a compromise position that would add some clarity around the Octane Fitness decision, but I think shifting the presumption really isn't the right way to go. And I disagree with Chairman Ice's characterization that even, post enactment of this legislative proposal, that it will be in the rare case. I think, if you shift the presumption, then basically you're saying that, the conventional wisdom is that you do shift fees. So anyway, I do think it's important to look at that issue through the perspective of small inventors and universities, and see if we really need to go that far to create the necessary disincentives.
So I think we'll have to leave it there, and this will be followed by lunch and a fireside chat with Michelle Lee and Jean Quinn. So please join me in thanking the panelists for what I thought was a good. Thank you.